hit subscribe. Subscribe to my guy, Uncle D. Tell him Big Bad sent you.
Spurling. I'm an attorney here in Houston, Texas. An advocate for black men, largely because I am a black man. I'm a black father. I have black sons. Hey, man, I do what I do.
Hello. Welcome, everybody. Welcome to the broadcast. My name is Dennis Spurling. Please hit the like button as you come in. As you all can see, I am in a different location. I am at my office, and this is what my office looks like. Normally, I operate from my studio, but I decided I had to, well, bottom line, I had some work to do, so I had to come down here and be in the office. But I think this is a perfect place to deliver this conversation. And the lessons that we're going to talk about is lessons on self-defense. If you can hear me clearly, type self-defense in the chat room. Type self-defense in the chat room if you can hear me clearly. Now, the thing about me is I'm an attorney. I practiced for approximately 26 years. Those degrees that you see up the wall and all across the wall in my office are numerous degrees and licenses and for jurisdictions all across the country. I'm actually licensed in 6 states. I actually have an LLM, so I could teach law if I wanted to, but I don't want to do that. But I do. Somebody says choppy. Is it choppy? Can you all hear me? Somebody says it's choppy. Is it choppy? Let me know if it's choppy. I'm doing the best I can. Okay, people are saying it's choppy. Let me know if it's choppy. I need to know. I need to know if it's choppy. If it's choppy, let me know. And I'll do the best I can. No, not choppy here. Okay, maybe somebody has some janky internet. But anyway, over the course of my career, I've handled thousands of cases and tried cases before juries, argued before judges, and appellate courts. And I spent decades studying how the law actually works. Now, how people wish, not how you wish it worked. And lately, through no fault of my own, Willie D, I found myself discussing some very controversial criminal cases, most recently, Carmelo Anthony. And what I've learned is that a lot of people get angry when they hear the law explained accurately. They get upset because the law doesn't always match their emotions. It doesn't always match what they want the outcome to be. And all I've done is explain what the law is. And that experience made me realize something very important. There are a lot of people who don't want to hear the truth. Now, if you can hear me clearly, type the truth in the chat room, but type the truth. But there are also a lot of people who don't want to hear who don't want to hear people lying to them. They want the truth, and who genuinely want to understand how self-defense works, and who need to hear it because one day their freedom or even their life may depend on it. So in this particular video, family, and this is going to be more like you're going to learn a lot, because I'm going to give you these real life instances that we've been dealing with. In this particular video, I'm going to explain to you all in detail how self-defense works using some cases that we all know of. Now, here's the thing. You all asked for this. I didn't ask to do this. Okay? You all asked for this, so I'm going to give it to you. I'm not going to lie to you. I'm going to give it to you. And I'm going to dispel some myths about some cases that you all thought you had a good understanding of, and you're probably not going to like me for it. Somebody type boule in the chat room. Somebody type sellout in the chat room. Go ahead. Somebody type agent in the chat room. Okay? Now, this video, we're going to take a look at, self-defense, how it works, because there's some misperceptions on it. Okay. All right. So in this video, we're going to talk about George Zimmerman. We're going to talk about Trayvon Martin. Okay. We'll discuss Carmelo Anthony. We'll discuss Rick Chow. We'll talk about Chud the Builder. And most importantly, we're going to discuss the actual law that applies to situations. And my goal is not to tell you what you like. My goal is to tell you my goal is to tell you how to interpret these. Okay. I'm not trying to teach you who to hate. My goal is not to tell you outcome you would want. My goal is to explain what the law says and why certain facts matter. Now, as a result of some of these discussions, people have called me every name in the book. They've been angry, right? You know that. Some of you all see them out here all the time. Search the internet. My type agent in the chat room. They say I'm getting paid. Who's paying me? I want to know. Okay. They've attacked me personally, but that's okay. The truth has a funny way of making people uncomfortable. And sometimes when the truth hurts, people holler. Somebody type holler in the chat room. In fact, I've learned something over the years. The more people holler, the more names they call me, the more I know I'm doing my job. And because my responsibility as an attorney isn't to tell people what they want to hear, my responsibility is to tell people what the law is. So let's put aside the politics, the emotions, the social media narratives, and the outrage for a moment, and let's look at the facts. Let's look at the law, and let's talk about what self-defense really means, and we're gonna learn something. And as I always say, if you learn something, I should earn something. Somebody remember that. You don't owe me anything, but if you learn something, I should earn something. But again, you don't owe me nothing. I don't want anything from you. If you can't, that's fine too. But I do need you to subscribe to the channel because we need people. And it should be refreshing for you all to have a lawyer who will speak the truth to you, because a lot of lawyers don't. They know they'll lose clients. A defense attorney can't get on here and tell you this stuff because he wants you all to contact him when he wants, when you need a criminal defense. A prosecutor certainly can't do it because his adversaries will use it against him. But me, a personal injury attorney, I don't have a dog in this hunt. All I need is about 100 car accident cases a year and I'll be fine. And crazy thing is, since this incident happened, people have been contacting my office from all over the country, referring me their personal injury cases, just saying, man, we just appreciate somebody who's telling us the truth. They've never met an honest lawyer. So that's pretty cool. And so, I'm being rewarded for speaking the truth. Okay. And I thank God that for whatever reason, the Lord put me in this position. Yeah, I don't practice criminal law. If you call me about a criminal law case, I'm going to refer you to someone else to tell you I can't help you. If you call me about personal injury, slip and fall, maybe I can help you. And on the flip side, if somebody was to ask me a position on a personal injury case or a class action case, I'm probably going to take the plaintiff's side because I'm going to be a little biased too. Why would I let my defense counterparts use that against me? But anyway, let's go ahead and talk about George Zimmerman and Trayvon Martin and why the case remains so controversial. And few self-defense cases in modern history have generated more controversy than that shooting of Trayvon Martin by George Zimmerman down in Sanford, Florida, back on February 26, 2012. And the basic facts are largely undisputed. George Zimmerman was serving as the neighborhood watch volunteer when he saw 17-year-old Trayvon Martin walking through the neighborhood. Now, Zimmerman called the police to report what he considered suspicious behavior, and then he started following Trayvon Martin. And at some point, a physical confrontation occurred between the two. Now, Trayvon Martin was a child at the time. I believe he was like 14. But during the struggle, Zimmerman fired a shot and killed Trayvon Martin. Now, one of the reasons the case became so controversial is that George Zimmerman was armed with a handgun and Trayvon Martin was unarmed. And on his face, that sounds like what? Well, you just killed an unarmed man. Mr. Spurling, you just sat up here and told us that the reason that Carmelo Anthony is going to prison is because he used force against a deadly force against Austin Metcalf, because Austin Metcalf was unarmed. Okay, remember that? So you going back on your word, Mr. Spur. What are you talking about? Right? I get it. Hold that thought. We'll get there. Okay. Now, again, one of the reasons the case became so controversial is because Zimmerman had a gun and Trayvon didn't have anything but his hands, his feet, and his elbows. And many people looked at those facts alone and concluded that the shooting could not possibly be self-defense because he literally brought a gun to a fist fight. Now, other people focused on the evidence presented at the trial indicating a physical fight occurred. Somebody typed fight in the chat room. And that Zimmerman suffered injuries, and that Zimmerman claimed he feared serious bodily injury or death at the moment he fired. I want y'all to remember that, okay? The case quickly became a national flashpoint because people viewed it through very different lenses. People who criticized, they argued that Zimmerman unnecessarily followed that boy and confronted him, and he created the circumstances that led to the shooting. And the supporters of a lot of the people who are supporting Carmelo Anthony, same people, they argued that whatever mistakes Zimmerman made before the fight began, and the legal question was what happened during the final moments of the confrontation and whether he reasonably believed he was facing imminent death of bodily harm. I want you to listen to me. Listen to me. Ultimately, the controversy stems from a simple but very difficult question. Does a person lose the right to claim self-defense simply because he had a gun and the other person doesn't? Now let's look at Florida law, because this is where this incident happened. Under Florida law, the answer is no. An unarmed person can still inflict serious bodily injury on it or death, and the law focuses on reasonableness. Somebody type reasonable man standard in the chat room. Reasonableness. Reasonableness of threat perceived at the moment deadly force is used. In other words, that's the instant where you pull that weapon out. Is it reasonable to believe that your life was about to be taken from you? That's the crucial thing. Now, that legal principle combined with the facts presented at trial is what made the Zimmerman case one of the most debated self-defense cases in American history. Florida self-defense law is found at Chapter 776 of the Florida statutes, particularly Section 776.012. And under Florida law, a person may use deadly force if he or she reasonably believes that such force is necessary to prevent imminent death, great bodily harm, or imminent commission of a forcible felony. In other words, somebody trying to rob you, huh? Pow, pow, right? Think about that. And if those conditions are met, the individual has no duty to retreat. They can stand his or her ground. And as long as the person is not engaged in criminal activity at the time and in that place where he has a legal right to be. So many people misunderstood Florida stand your ground law. It doesn't mean that whoever throws the first punch is automatically loses the right to self-defense. That's not what Florida law says. It doesn't mean that a person can use deadly force simply because they're afraid. Nor does it mean that, and shout out to Faquan, thank you so much for being the first person to contribute to the super chat. Again, let me go back to Florida law. It also doesn't mean that a person can use deadly force simply because they're afraid. And it doesn't mean that someone can pursue or provoke another person and then automatically claim self-defense. The central question in virtually every self-defense case is whether the defendant reasonably believed that he or she faced imminent death or great bodily harm at the moment. Somebody type at the moment. At the moment deadly force is used. And the jurors are instructed to evaluate the circumstances from the perspective of a reasonable person in that situation. Somebody type reasonable man standard. And that's going to be something y'all need to understand. And I'm going to go into that in a little bit more detail. The law allows you to be wrong. The law allows you to make mistakes. Doing something reasonable doesn't necessarily mean that you were accurate at the time. Somebody type reasonable man standard. It's the first thing, one of the first things you learn in law school. The reasonable man standard. All right. Now, let's go back into this law. Y'all learning? You're going to learn something. Keep up. All right? Again, Florida law also places important limitations on self-defense claims by the person who initially were the aggressors. And generally speaking, a person can't provoke a confrontation and then immediately claim self-defense. However, there are exceptions. An aggressor may regain the right to self-defense if the confrontation escalates. Somebody type escalates. It escalates to the point where he reasonably fears imminent death or great bodily harm and has no reasonable alternative. In other words, there's no way out. He's got his back against the wall. Okay? He's on his back on the ground. Or if he clearly withdraws from the encounter and the other party continues to attack. So if he tries to run away and the person keeps coming at him using deadly force, you got a right to use it. And these principles explain why George Zimmerman and Trayvon Martin case became so controversial because, you know, contrary to popular belief, the central legal issue was never whether Zimmerman had a firearm and Martin didn't, okay? Nor was the legal question centered about race, even though George Zimmerman, I believe he was a Latino person, a white Jewish person, white Latino, I'm not sure. And of course, Trayvon Martin was a black boy. But the critical question before the jury was whether George Zimmerman reasonably believed he was facing imminent death or great bodily harm. Now, ultimately, the jury concluded that the state failed to prove beyond a reasonable doubt that the shooting was unlawful and Zimmerman was acquitted. And so Florida's self-defense law and the prosecution burden played a significant role. Now, I want y'all to listen. Now, look, you all asked for this, okay? Y'all asked for this. People have been asking me to analyze the Trayvon Martin case and explain it to them. I didn't want to do it. This is not something I want to do. I was going to talk about history. I was going to talk about how white people, you know, gave up their culture when they came over to the United States. That was going to be the conversation because in celebration of all these European folk who coming over here and invaded all our fast food restaurants, that's what I plan to talk about, but I can't get to that because you all want me to tell you the truth. Am I the only lawyer on the internet that will tell you the truth? Apparently so. Okay. Now, let's talk about the Trayvon Martin, George Zimmerman trial. Okay. Now, the evidence presented, because that's the only thing that matters. I don't care what the internet says. The only thing that matters is, and shout out to Denny Ace, the only thing that matters is the evidence presented at trial. And the evidence presented showed that Zimmerman had followed Martin after reporting him to the police, that a fight, a physical confrontation happened between them, and Zimmerman suffered injuries to his face and head. Somebody typed face and head. And the witnesses described a struggle on the ground. Somebody typed ground and pound in the chat room. Are y'all listening? Zimmerman claimed Martin was hitting him in his head or hitting his head against the pavement. I want you to picture this. Okay? I want you to picture this. You have somebody on top of you punching you in the face, striking your head against the pavement on the ground, concrete, not grass, not a pillow, on the concrete. How many of those blows do you think is necessary before you black out? I'm asking. And I'll just listen now. Listen. How many of those blows do you think is necessary before you pass out? And if you don't believe me, don't try this at home. But what I want you to do is let somebody get on top of you and hit you in your face and then grab your head. I don't want you to do that. But if someone did, hypothetically, jump on top of you, grab your head and start bashing your head into the pavement, how long do you think you will remain conscious? And the bigger question is, at what point do you think that rises to serious bodily harm that, or at least, at what point is it deadly force? Somebody type ground and pound, okay? So again, the prosecution was trying to put Zimmerman in jail. They said he unnecessarily followed and confronted Trayvon Martin, and the shooting was not justified. And guess what the defendant said? The defendant said that Zimmerman was beaten, feared serious bodily injury or death, and then he fired when he believed he had no other option. In other words, and I want you to listen because I know you're mad. Somebody typed coon in the chat room. I'm reading the law to you and I'm explaining to you what happened, and you all are mad because I'm telling you what happened. Don't you want to know? You asked for it. You asked for it. You got somebody, the jury heard evidence that Trayvon Martin was on top of George Zimmerman, punching him in the face and trying to bash his head into the concrete. Now, that's the facts that came out. I'm just saying. If that makes me boule or coon or whatever, because you don't want to hear excuse me, praise Jesus, you don't want to hear the facts, whose fault is that? Is that my fault? You asked for this. And see, here's the problem with people. You ask questions that you really don't want the answer to. You know, oftentimes old people to tell young people, leave that alone. You don't want to know. You keep asking your grandma and your aunties who your real daddy is. You 30-some years old, you don't want to know. You keep asking. And then you know what? You go ahead and keep asking, and somebody finally tell you, you find out that your mama's uncle is your biological father. You mean Uncle Henry? Your Uncle Henry is your biological father. You shouldn't ask the damn. Now your feelings hurt. You see, that's where we are right now. Now your feelings are hurt. So the evidence showed, the prosecution, the evidence showed that Zimmerman was getting beat, getting his head bashed into the ground. And so he pulled out his weapon and shot Trayvon Martin. That's what the evidence showed. And then the defense counsel further emphasized that the head injuries can be fatal. I think we all can agree with that. If somebody is bashing your head into the concrete, we can agree that you can die from that. Does that make me a coon for telling you that? That's that's honesty. This is what you asked for. I'm giving it to you. This is the law. This is why that man walked out the courtroom. Does that make you angry? See, you look, you see that? It takes me, it don't take this many degrees and plaques on the wall to figure out if somebody's bashing your head into the ground, you're gonna live very long, right? Right? Huh? Are you mad? I hope y'all mad. I hope y'all good and mad. Because this is what you asked for. This is what you asked for, and this is what I'm giving to you. Now, you had somebody on top of you punching you in the face and bashing your head into the ground. And for that reason, they said Trayvon, even though Trayvon Martin didn't have a weapon, it didn't automatically eliminate George Zimmerman's right to claim self-defense, even though he used a deadly weapon, i.e. a pistol, and shot it. Now, people believe that Zimmerman's decision to follow should have automatically prevented him from asserting self-defense. However, Florida law, and if you don't like Florida law, just move out of Florida. That's simple, right? You don't like it, move to New York. I want y'all to all move to Baltimore. If you don't like Florida law, move to Baltimore, move to Chicago. They don't have those laws there. Go on, move to Chicago, okay? But again, under Florida law, merely following someone is not the same thing as committing a forcible felony or initiating a physical attack. And the prosecution still had the burden of proving beyond a reasonable doubt that Zimmerman was not acting in a lawful self-defense when he pulled the trigger. And the jury ultimately concluded that the state failed to meet that burden. And the burden of proof perhaps was the most important factor in the case. Zimmerman was not required to prove that he acted in self-defense. Rather, once the evidence supported self-defense, once it was introduced, once the evidence showed that this man was trying to bash his head into the concrete, right? The burden shifted on the state to show that that was unreasonable to use self-defense when somebody's trying to bash your head into the ground. That's what happened. You don't have to like the verdict. All this could have been ignored if George Zimmerman hadn't followed Trayvon Martin. We can all agree to that. But that's not what happened. Bottom line is the jury ultimately found that there was reasonable doubt concerning what occurred during the final moments of the struggle and returned a verdict of not guilty. And that case remains controversial because people focus on different parts of the encounter. Critics emphasize that Zimmerman chose to follow Martin and arguably created the circumstances that led to the confrontation. Agreed. And then people who support a focus on the evidence that the physical struggle occurred and that Zimmerman had reasonably feared serious bodily injury when the boy was trying to bash his head into the ground. Okay, So y'all don't agree. Got it. Okay? But the distinction is one of the most important lessons from the case. Self-defense law focuses on the reasonableness of the perceived threat at the moment force is used, not merely on who possesses a weapon. And the broader lesson is very straightforward. Don't continue beating someone on the ground. Does that make sense? We see that on IG all day. Somebody falls down and you jump on top of them and beat them. They literally can pull out a pistol or a weapon and take your life at that. But that's what this law says. That's what it's saying. Keep playing. Once you're on top of a person, striking them and pinning them down or otherwise placing them in a position where a reasonable person should fear or would fear for their life, you may be creating a legal justification for deadly force to be used against you. Keep that in mind. Does that make sense? See, the law recognizes that a third, and even a third person coming by who reasonably believes that someone is facing imminent death or serious bodily injury may intervene in that defense of that person. In other words, if you find yourself in a situation, you done came up out the club and you on top of somebody, beating them up and pounding them out, bashing their head into the ground, and somebody comes along and busts a cap in you, they had a right to use that deadly force because you was about to kill somebody. Somebody type ground and pound can get your life took in the chat room. You see? And that's the practical takeaway of this. It's simple. When a fight reaches the point where one person is down and unable to effectively defend himself, the legal risks change dramatically. What may have begun as a fist fight can quickly become a situation in which deadly force is legally justified. And the smartest course of action is to not continue to attack somebody when they're on the ground. The smartest course of action is to disengage and walk away as soon as possible. Now, does that make you mad for me telling you that? It should if you're delusional, because that's good old-fashioned common sense. That's why you don't kick people on the ground. It's an old saying that says that. Now, let's move on to the next one, since y'all good and hot. Somebody type, we hot, boss. Ha ha, yeah. Hope y'all good and mad up in here, baby. Got me in my office working late. Now, let's talk about Rick Chow. That's another one that made you mad. Rick Chow walked free. Rick Chow. You know about this case? This is one that happened a few weeks ago. A young man comes into a convenience store. He attempts to, what appears to be, take some bottles of water, put them underneath his clothing, then puts the 4 bottles of water back, and he walks out. He's confronted by Rick Chow's wife. She tells him to stop and empty his pockets. He refuses to, and then he takes off out. He's confronted by Andy Chow, who's Rick Chow's son, and then Rick Chow and his son Andy Chow take chase. They chase him 130 yards, and the next thing we know, this young man, Cyrus Belton, is dead, shot to death by Rick Chow. That's the basic facts, right? It was an injustice, right? Y'all mad, right? Be mad. You still gonna hear what happened. Just because you don't like it, you're still gonna hear it if you're on this page. Because this is the facts. This is the truth. Be mad. Now let's talk about South Carolina law. The relevant language is this: a person who is not engaged in unlawful activity. In other words, you're not committing a crime at the time and is in a place where he has a right to be and has no duty to retreat. In other words, you're not trespassing on somebody else's property, right? And you don't have to leave. He can use deadly force if he reasonably believes. Somebody type reasonable man standard. First thing you learn in law school, first week, reasonable man standard. Shout out to everybody contributing to the super chat. I don't care if y'all mad. You're going to learn something because I'm going to save your life. You're going to stop giving that bad advice. Somebody hits you, you hit them back harder. You make sure they knocked out. No, we're not going to do that. We're going to stop acting like that. We're going to stop acting like this is a free-for-all. You can't do what you want to do just somebody touch you. You can't. You got to control yourself. Somebody type self-control in the chat room. Can't lose your mind because you're mad. Or you're going to end up in prison or somebody might come along and pop you. Now, again, deadly force, if he reasonably believes it's necessary to prevent death of great bodily harm to himself or another person. The key phrase is reasonably believes. And the law doesn't say if the victim was actually going to shoot. You understand that? If the victim, it doesn't say if the victim actually intended to kill someone. It doesn't if the defendant perception was ultimately correct. And so the law asks whether a reasonable person standing in Rick Chow's shoes would have believed his son was facing imminent death or great bodily injury. Now, let's apply that to the facts. I want y'all to hear this. Number one, Cyrus Belton was armed. He had a pistol. He had a semi-automatic weapon. And that matters because the jury was not evaluating a fist fight. You understand me? So according to the testimony, okay, and testimony is when somebody gets up on the stand and they take the stand and they begin to speak, and then the other side has an opportunity to cross-examine them. And at this point, they've had months and years to figure out if this person is lying or not. But anyway, that's why we call it testimony. According to the testimony, the jury heard the evidence that Belton possessed a semi-automatic pistol. That's what the jury heard. And that changes the level of threat being evaluated. A firearm is inherently capable of causing death or great bodily injury. The question becomes what Rick Chow reasonably perceived at that moment. Okay? Now, if the jury believed that Cyrus Belton pointing the pistol at Andy Chow, who is Rick Chow's son, then the legal question becomes, would a reasonable father witnessing that event believe his son was about to lose his life or suffer serious damage? Would you believe if somebody was pointing a pistol at your son or daughter? What would you do at that point? I'm asking all the parents out there. If you're a daddy and somebody's pointing a gun at your child, you have a right to make a mistake and assume that that person is about to kill your child. That's what reasonable man standard sounds like. That person might not even have any bullets in the car. It might be a fake gun. But if you reasonably believe that your child's life is in danger because somebody's pointing a gun at them, you have a right to use deadly force in the defense of the person of another. Does that make sense? That's the law. Does that make you angry to hear that? I mean, I'm just saying. What would you do? Huh? Because see, that's the exact inquiry required of the statute. Now, this is the point many commoners miss. Suppose Belton never fired the gun. Suppose he was bluffing. Suppose Cyrus was about to lower the weapon. Those facts would not necessarily defeat a self-defense of others' claim if Rick Chow reasonably believed deadly force was about to be used against his son. The law doesn't require perfection. It requires reasonableness. What did the jury hear? Because this is the evidence. I don't care what the internet says. This is what the jury heard. The jury heard a direct examination. They heard cross-examination. They heard they saw physical evidence. They had other witness testimony. They got the court's instructions on South Carolina law. They're not permitted to decide the case based on social media discussions or public opinion or theories. Stuff that wasn't admitted into evidence. They don't talk about that. And after hearing the evidence, the jury concluded that Rick Chow believed it was reasonable under the circumstances to shoot Cyrus Belton. Now, one thing people often misunderstand is that law doesn't require a person to be correct. Do you hear me? I want y'all to hear this. I want you to hear this. The law requires that a person's belief be reasonable under the circumstances. You always wonder why all these cops are able to get off for shooting people. The question wasn't whether or not the person had a gun or not. The question was whether the cops believed that they had a gun or his life or his partner's life or the public's life was in danger was reasonable. Reasonable man standard. It allows you to be incorrect. It allows you to be totally wrong as long as you acted reasonably. Do you understand that? Is that something that you can contemplate? Seems unfair, right? Damn, that's not even fair. The law requires that the person's belief be reasonable under the circumstances as they appeared at the moment. And this is called the reasonable man standard. Somebody type reasonable man standard in the chat room. So the question under South Carolina law was whether Rick Chow reasonably believed his son, Andy Chow, was facing imminent death or serious bodily harm. According to the testimony, and it was Andy Chow, that's his son. And I know y'all don't like that because that's his son. He biased. I get that. I get that. He testified to Cyrus Bell, Andy Chow, after chasing this boy for 130 yards with his father behind him. He testified that Cyrus Belton pulled a semi-automatic pistol and pointed it at him. And once that testimony was admitted, right, again, the prosecutor cross-examined him, and the jury heard his testimony under direct exam from the defense counsel, and they heard his cross-examination. But it was admitted. That's what the jury heard. And they evaluated whether Rick Chow's action was reasonable based on what he perceived at the moment. And many people watching from the outside, you disagree. I get that. You believe Rick Chow, you believe Andy Chow was lying. You believe Rick Chow was lying. You believe that they were covering for themselves. And that may very well be so. You see? But the question is never never whether Rick Chow was perfect. The question was whether a reasonable person standing in Rick Chow's shoes, seeing what he claimed to have seen, would have believed that his son was about to be killed or seriously injured. And the jury answered the question, yes, it's reasonable to believe that. And that's the law of defense of others. Is that clear? It don't matter if you like it or not. Is that clear? Do you understand what has just been taught to you? Reasonable man standard allows you to be wrong. It allows you to be correct as long as you acted reasonably. Is that clear? And see, here's the lesson from Rick Chow's case. Don't put people in reasonable fear that they're about to lose their life or suffer serious bodily injury. If you find yourself screaming at somebody, losing control of your emotions, reaching into your pocket, claiming you have a gun, acting like you have a gun, reaching for something that could be used as a dangerous weapon, picking up a stick, a bat, a tie iron, a knife, any object capable of causing serious harm, you're creating a potentially deadly situation. The law does not require people to wait until you actually use that weapon. If a reasonable person believes that deadly force or serious bodily injury is about to happen, then they have a right to respond with deadly force. Do you see how that works? Somebody type jump bad if you want to. Somebody type jump bad if you want to. Okay, that's what I'm trying to explain. You can jump bad if you can all act all big and bad like you about to pop trunk. Somebody type pop trunk in the chat room. And see, here's something else people don't understand. It doesn't even have to be directed at them. If you're threatening someone else with a dangerous weapon, okay, a third party, which could be your mama, your daddy, your cousin, or even a passerby who witnesses that encounter, they may lawfully come to that person's defense if they reasonably believe the victim is facing imminent death or serious bodily injury. Damn, you mean somebody else could come up and smoke you? Yes, that's what I'm trying to explain to you. Somebody type pop trunk in the chat room. Okay? They don't even have to know the victim. They don't have to know you. They don't even have to know the full story. You could be in the right. They could be in the wrong. As long as they're not committing a crime, not somewhere they shouldn't be, if they use deadly force to stop you from using deadly force against somebody else, right? They have a legitimate self-defense claim. Again, you could be trying to recover your property from somebody and pull out a pistol, and somebody looks at that and says, it look like he's robbing them. And they pull the pistol on you, and you turn around at them and they shoot you before you get a chance to do anything, and you trying to recover your property. You see how that works? Do you see how that works? They don't even have to know the full story as long as they were reasonable in how they acted at the moment. And see, the law generally evaluates situation from the perspective of a reasonable person observing what happens to be an imminent deadly threat. And the takeaway is straightforward. Control yourself. Don't play games with weapons. Don't pretend to have a weapon. Don't make threats you don't intend to carry out. Don't create the appearance that you're about to kill or seriously injure someone, because you never know who's watching. And you never know who may decide to intervene and what they may do. And what may seem like intimidation or posturing, somebody type jump bad, bluffing, it may seem like that to you, but other people might see it as a deadly threat. And everyone around you might see that. And once you create that reasonable perception, you are gambling with your life. Does that make you mad for me telling you that? Does that make me angry? Huh? Are you angry for me telling you that? Does that make me a boule, coon? What do they say? Give me all the words. I want to see all the words. Come on, give me all the words. Fake, all the words. Give me all the, I'm a fake lawyer. All of that. You don't know what you're talking about. Come on, give me all those words. Let's hear them. Now, somebody type now in the chat room. Now, let's proceed. Let's proceed. Are you learning something? You don't have to like it, but you're learning. That's all. I'm not trying to win a popularity contest. I'm not running for office. I don't even want your little funky dollars. I like the truth. I'm in it for the legacy. Yeah, you got the right one. See, black folk are used to people needing you. I don't need you. You understand that? That's the difference between me and all these other folk. I'm good over here. Somebody type, he good in the chat room. He good. You understand? I'm probably the last lawyer you're going to ever meet to speak the truth to you like this, unabashedly. I don't care about you like that. I don't care about hurting your little feelings. I'm not trying to win a popularity contest. Don't matter to me. You understand? I done got to the point in my life, it don't care if you like me or not. I'm going to keep hitting you upside the head with these facts until you learn something. We are saving lives today. Somebody type saving lives, one at a time. That ugly truth. This is that ice cold truth. Somebody type Blizzard King in the chat room. Yeah, buddy. The Blizzard King. Yeah. Now, y'all ready to move forward? Let's talk about Carmelo Anthony and why his self-defense argument failed under Texas law. But Uncle D, we don't understand. I know you don't. Why could George Zimmerman had a weapon, but he got off free? And Trayvon was unarmed. I know. That's why you got to listen. Okay? This law recognizes the right to self-defense. Right? And I hope I don't need to refresh y'all about Carmelo Anthony's case that happened in Collin County, Texas. Had two young men at a track meet. One young man was sitting under a tent. Another young man came over and told him to move. It was a little jaw-jacking back and forth going on. And one young man put his hands on another young man and pushed him, tried to get him out the tent. And instead of coming back with a push, the young man came back with a knife straight through the ventricle of the heart. And the other young man bled to death. And in any other circumstances, everybody would say, yeah, that young man who stabbed him, he probably gonna go to prison. So you got a dead body, a knife, dozens of witnesses, broad daylight, and the young man confessed. That was Carmelo Anthony. The only thing that makes this that controversial is that one of them was black and one of them was white. And you know, in America, racism is our national pastime. So when it comes to racism, we all got to participate. Don't lie. Don't lie. You know you like it. It's like a football game during the off season. You rooting for your team. Win, lose, or draw. Shout out to Curry Smith. This is what we do here in America. Racism. Racism. And this is the game that we play. But it don't matter to me. So now, this case went up. As you all know, Carmelo Anthony was tried and convicted and sentenced to 35 years in prison. the jury disregarded his self-defense claim. And so now we're going to analyze this. And I know you still hot. Somebody type, we mad in the chat room. Be mad. That's good. I like talking to people when they mad. Be mad. But we still going to talk about this law. See, Texas law recognizes you have the right to self-defense. Right is not unlimited. You understand what I'm saying? Shout out to Houston 3987. You have the right to self-defense. But that law is not unlimited. Under Texas Penal Code, subsection 9.31, a person is justified in using force against another when and to the degree that the person reasonably believes. There's that readable man standard again. The person reasonably believes force is immediately necessary to protect against another use or attempted use of unlawful force. Okay? That's what that says. In other words, if somebody puts hands on you, you have a right to put hands on them. All right? Hands. That's what it says. That's what the law says. Okay, now let's go on to the next one. However, when a person escalates from ordinary force to deadly force, so you go from feet and elbows to pulling out guns and knives, then Texas Penal Code subsection 9.32 comes in. It imposes a strict standard. Deadly force is justified only when the actor reasonably believes it is immediately necessary to protect against another's use or attempted use of unlawful deadly force to prevent certain serious violent crimes, okay? Like robbery or something like that. But that's not the situation we're dealing with. The critical issue in the Carmelo Anthony case wasn't whether Austin Metcalf touched him or confronted him or even attempted to remove him from the area. The legal question was whether Carmelo Anthony believed or reasonably believed that the deadly force was immediately necessary at the moment he used the knife against the unarmed Austin Metcalf, okay? Now, under Texas law, self-defense is governed by the principle of proportionality. Okay, a person may respond to force with force, but the response must be reasonable under the circumstances. The law doesn't permit a person to automatically respond to non-deadly force with deadly force. Not automatic. And based on the facts, somebody type the facts. Based on the facts publicly reported, Austin Metcalf was unarmed. There was no evidence that he possessed a firearm, a knife, or other deadly weapon, nor was there any evidence that he was attempting to use unlawful deadly force against Carmelo Anthony. In other words, unlike the Trayvon Martin case, Austin Metcalf was not on top of Trayvon Martin bashing his head into the concrete. You see the difference? Is that hard to understand? Do y'all get that? Does that register? Because you keep trying to compare this case to Trayvon Martin. Trayvon Martin was on top of George Zimmerman, pounding him out, trying to bash his head into the concrete. This is not that situation. There's a big difference between shooting somebody who's on top of you, grounding, pounding, you trying to bash your head into the concrete, and stabbing somebody after they pushed you. Do you see the difference? I'm just saying, come on now, let's get the word, boule. Come on, where's the rest of the words at? Agent, paid off, let's do, I get that. I know it makes you angry, but you're still gonna hear the facts. We're gonna think logically here. Those are the facts. There's no evidence that Austin Metcalf had a gun or a knife or a deadly weapon. There's no evidence he was attempting to use unlawful deadly force. In other words, he wasn't on top of him, pounding him out, bashing his head into the concrete. And as a result, the prosecution's position was that whatever force Austin Metcalf may have used or threatened didn't justify the use of deadly force in response. In other words, him pushing him didn't justify him stabbing him in his heart. That's it. And under Texas law, a jury can conclude that while a defendant had a right to defend himself against ordinary force, in other words, I'm not telling black children they shouldn't protect themselves. I'm not even saying turn the other cheek. Do you hear that? All you people out there, I'm not saying turn the other cheek. I'm saying if somebody pushes you, push them back. If somebody punches you, punch them back. If somebody pushes you, punch them. That's what I'm saying. Does that make you angry? Because see, that type of force is ordinary. In fact, it's expected. Somebody push you and you push them back. Well, that's pretty much how it works. Y'all might get suspended, but you had a right to do that. Now, of course, you should always walk away if you can. Okay? That's ordinary force. You have a right to defend yourself with ordinary force if somebody else used ordinary force against you. But what you don't have a right to do is escalate the encounter to deadly force unless a reasonable person in that same situation would believe that death or serious bodily injury was imminent. Who amongst you all thinks that being pushed is going to cause you to die? How many of y'all think being pushed is going to cause? How many of y'all think that these two 17-year-old boys, both who played football, one of them pushed the other one, how many of you all think that's going to cause you to die? I'm just asking. Do you, at what point, don't ever go to a concert again because you're going to get pushed. Don't ever go to a crowded event. Don't go to a club. Don't go to a comedy show. You're going to get pushed. If you think being pushed is going to cause death, you need to stay at the house. You understand that? And the jury felt the same way, even if it was a linebacker push. This is not some old 75-year-old feeble woman that he pushed. He pushed a 17-year-old boy who also played football. That's not going to cause him death. You understand that? Is that hard to understand? Who didn't get that part? Because, see, that's what a lot of people are stuck on. Again, you don't have a right to escalate the encounter to deadly force unless a reasonable person in the same situation would have believed that death or serious bodily injury was imminent. Do y'all understand that? And see, that distinction is lost in these public discussions about self-defense. The law does not ask whether a person had a right to defend himself. The law asks whether the level of force used was reasonable. Okay? We understand that people have a right to defend themselves. That's understood. Of course you should. But a shove doesn't justify stabbing somebody or shooting somebody. A punch doesn't automatically justify, hitting somebody with a tire iron. And the response has to be proportionate to the threat. In the Carmelo Anthony case, the state's argument was essentially that even if Anthony had the right to resist or defend himself, using a knife against an unarmed individual who wasn't on top of you, bashing your head into the concrete, kicking you in the face, you stabbing the person standing up in front of you after they push you, that constituted unreasonable escalation of force under the circumstances. And see, the lesson from that case is that self-defense is not a blank check to kill. Texas law, like most states, allow a person to protect themselves, but it requires that the force used be reasonable and proportionate to the threat faced. When someone responds to ordinary force with deadly force, the question becomes whether a reasonable person would have believed that deadly force was immediately necessary to protect their lives. And if the answer is no, then the self-defense claim fails. And that's why the central issue in the Carmelo Anthony case wasn't whether he had a right to defend himself, but whether the use of deadly force against an unarmed Austin Metcalf was reasonable and lawful, a lawful response under Texas law. Does that register? Do y'all get that? Okay, do you see the difference between that case and Trayvon Martin? Trayvon Martin was on top of George Zimmerman, bashing his head into the concrete. Search the internet for the man's face. That was the testimony. And you ask yourself, if you have a gun and somebody is on top of you, bashing your head into the concrete, what would you do? I'm just asking. It's not like they're up there and they just controlling you. They're on top of you, bashing your head into the concrete. What would you do? If you came by and you saw your son on the ground, on the back, and some other boy was bashing his head and had got the best of him and was bashing his head into the concrete, what are you going to do? Maybe you'll jump over there and try to get him off. That would be reasonable. But if he about to kill your son and you pop him, the jury might say, well, they were trying to protect their son from reasonable bodily injury. Does that make sense? Because see, if I see somebody I love, they on the ground and they getting bashed, the head getting bashed into the concrete, I'm gonna think, yeah, I'm gonna have to, yeah, you about to kill them. And if you're using deadly force to protect the life of another person or try to prevent them from having serious bodily harm, and I don't think anybody here would disagree that having your brains scattered across the pavement after somebody done bashed it on the ground, I think we all can agree that's serious bodily harm, right? We can agree to that, right? Can we? Are we? Come on, let's get, where my Boule people at? Boule, Kim, let's hear it. Because your little ears are burning. You don't want to hear the truth. This is the truth. That's the difference between Austin Metcalf and Carmelo Anthony and Trayvon Martin and George Zimmerman. Had Austin Metcalf jumped on top of Carmelo Anthony and began to beat him and bash his head into the concrete, clearly he was attempting serious bodily injury or was about to, or death was imminent. Carmelo Anthony would have been justified in using his knife to stab Austin Metcalf. But that was not the situation here. At least that's not the evidence that was testified to. Now, I'm going to go back to this. What's another lesson learned? Now, the real lesson from the Carmelo Anthony case is understanding what the facts would have changed if all these internet rumors was true. Now, let's say the evidence has shown that Austin Metcalf and his brother and several other people were physically assaulting Carmelo Anthony at the same time. They was double teaming him, triple teaming him, or quadruple teaming him. Okay? See, in that particular situation, the self-defense analysis would have looked very different. Okay? I want y'all to look. Let's go with me now. It's one thing if one person push you. It's another thing that 4 people are around you putting hands on you. You see the difference? Do y'all see the difference yet? Huh? Do you see the difference? Okay, and why is that different? And for some of y'all, you don't understand, so I'm gonna explain why. Because Texas law doesn't require a person to wait until he's beaten unconscious or killed before defending himself. A reasonable person can conclude that if you got multiple people around you, that they are capable of causing serious bodily injury or death. We can agree with that. That's reasonable, right? Even if none of them are armed, none of them had a weapon. 4-on-1 is not the same thing as 1-on-1. A jury could reasonably find that being surrounded and attacked by multiple people, and I'm talking about other damn near grown boys, 17 big boys, old enough for the Marine Corps, right? A jury is going to say, yeah, that creates a threat of deadly force or serious bodily injury sufficient to justify deadly force response. Here's the thing. They didn't even have to hit him. Even if all of them had started pushing him, he might have mistaken that for they about to hit me and beat me up and stomp me out and put me on the ground. Reasonable man standard allows you to make a mistake. It might be a stretch. Well, I mean, they never actually hit you, did it? Yeah, but they were pushing me and I thought they were about to. I don't have to wait around for them to hit me. I can make the mistake as long as I'm acting as what a reasonable man, how a reasonable man would act if 4 people putting hands on him. And so the jury could reasonably find that being surrounded and attacked or touched by multiple people, especially men, creates a threat of deadly force or serious bodily injury sufficient to justify deadly force in response. Does that make sense? Huh? Do you all understand that? So if the facts were, and these are not the facts in this case with Carmelo Anthony, I just want to be clear that none of that came in. None of the dozens of witnesses said that multiple people attacked him. Nobody said he was pushed to the ground and nobody was jumping on top of him. He wasn't getting stomped in the face. None of that stuff I see us doing on the internet, Instagram. I don't know why my For You page is so violent, but I see all kind of crazy stuff. You understand? None of that was said. What we know is that it was one boy who pushed another boy and that boy stabbed. That's all we know. It wasn't multiple people, but I'm entertaining your internet propaganda and conspiracy theories. That's what we're doing. Okay, so if it was a 4-on-1 situation, he would be justified in using deadly force. It's reasonable to believe that. Even if they testimony was we were just pushing him, we were never going to hit him. He didn't know that. And so he acted as a reasonable person, that he's allowed to make that mistake. That's what a reasonable man standard allows you to do. But again, that brings us to the lesson that applies far beyond this case. Every day, you can go on Instagram and TikTok and YouTube and watch videos of groups of people jumping a single person. And you see people stomping on somebody's head while he's on the ground, or her head. You see multiple people kicking someone who can no longer defend themselves. You see crowds piling on to one person. And what many people don't understand is that that conduct can transform what started as a fist fight into some deadly force situation. If someone is on the ground being kicked or stomped or beaten by multiple attackers, a jury can conclude that he or she reasonably feared death or serious bodily injury. And if that person then produces a weapon and uses deadly force against one or more of his attackers, a self-defense claim becomes very strong, because the law focuses on reasonableness of the perceived threat at the moment, not simply whether the attackers were armed or not. And that same principle can be applied even if the victim is standing. If a bunch of people, attackers, can inflict catastrophic injury without ever displaying a weapon. You understand what that means? We know that. So it's saying, yeah, a reasonable person would believe they're going to hurt me, so I'm going to use, they could kill me, so I'm going to use deadly force. And see, the law allows people to make reasonable judgments under stress situations at that moment. And the person being attacked by multiple people doesn't have to know for certain that they were about to kill him. He doesn't have to wait until his skull is fractured, until he loses consciousness to come back shooting. The question is whether a reasonable person in the same situation would believe that death or serious bodily injury was imminent. And the practical lesson is simple. Stop jumping people. You understand me? Stop surrounding people. Y'all need to stop participating in that mob violence that I see on Instagram all the time. Somebody gonna get shot. Don't stomp people when they're on the ground. Because if you attack the wrong person and that person believes he's facing death or serious bodily injury, the law permits him to use deadly force in response, even if they started it. Even if somebody pushed you first and you push them back and you start fighting them and all your homeboys and homegirls jump in, he started the fight and then y'all got him on the ground, he has the right to bust a cap in y'all. And if a jury agrees that his fear of death was reasonable under those circumstances, and they probably will, he's not going to be found criminally liable for what happens next. You understand what I'm saying? Y'all can catch a one-on-one fade, but don't catch a case. That's my point. Now, are you mad? Where are my mad people? Where are my hate? Somebody type hate watcher in the chat room. Got me up here working late. Somebody type hate watcher in the chat room. I hope you're mad. But I'm saving lives. I'm saving lives. I know that. I know you learned something. I bet you did. Even just now. Like I said, we're going to keep it moving. If you enjoy this, all my people who are enjoying this lesson in the law, type number 1 in the chat room. If you're enjoying the lessons in the law, type number 1 in the chat room. If you think this is helpful, type number 1 in the chat room. If you've learned something, type number 1 in the chat room, because this is for you. You're my number 1. I don't do this for money. I do this because I care about you. I do this because I enjoy spreading the truth. The truth is our friend. That's right. They hate the truth. They don't want it. They want to be told what makes them feel good, and I'm not going to do it. But that's all right. Now, let's move on. Chud the prisoner, also known as Dalton Eatherly. Y'all know Chud the prisoner, formerly known as Chud the builder. Y'all listening? So Chud the Builder, Tennessee-based live streamer, you all know this, internet personality. Somebody type chimp out in the chat room. Somebody type chimp out in the chat room. Mr. Chimp out himself, right? What this guy would do a few months back, he would go around recording controversial encounters in public with black people, using inflammatory language, calling people the N-word with the hard ER, making these racially provocative language to generate online attention, telling people to stop chimping out. And so in May 2026, Dalton Eatherly, also known as Chud the Builder, now known as Chud the Prisoner, he became the center of national attention after a confrontation outside of Montgomery County Courthouse in Clarksville, Tennessee. Now, who causes trouble in front of a courthouse? You going to prison just for that, sir. The judge, they're never going to let you out. If you bold enough to cause trouble in front of the courthouse, you know the judge is out there. You could have shot somebody that the judge loves. You understand how that works? You took it too far. Too damn far. Okay? So anyway, Chud the Prisoner starting trouble outside the Clarksville, Tennessee courthouse. It escalated to a shooting, and Eatherly claimed he acted in self-defense. So here we go, self-defense. Self-defense. And the prosecutors charged him with attempted murder and some other felony offenses. Now, as with many controversial self-defense cases, the legal question is not whether people approve of the defendant's behavior or speech. The truth is, Chud the Prisoner had the right to go harassing people and call them chimps and N-words. If you don't want to hear it, get away from around it. I mean, I know it's free speech. We hate it. Yeah, I know. It's what makes us great, and it's what makes us, it creates hate. But bottom line is, he can say what he want to say. Okay, so the question is whether at that moment force was used, Tennessee law justified the use of deadly force. And the question we must begin, we got to start with the Tennessee self-defense statute. Now, I've read the South Carolina self-defense statute. I've read the Texas self-defense statute. I read the Florida self-defense statute. We talked about George Zimmerman. We talked about Trayvon Martin. We talked about Cyrus Belton and Rick Chow. We talked about, just talked about Carmelo Anthony and Austin Metcalf. All of these are self-defense cases, okay? So now we're going to talk about Tennessee, and we're going to talk about their self-defense statute. Now, what you're learning is a lot of these self-defense statutes are pretty much identical. Have we learned that? Somebody type reasonable man standard in the chat room. Okay, so let me give you some homework. Tennessee self-defense statute, Tennessee Code annotated subsection 39-11-611. Tennessee self-defense law is found in Tennessee's Code annotated. It's just the law book, okay? Tennessee is a stand your ground state, meaning that a person who is lawfully present and not committing a crime, which basically not involved in any unlawful activity, they don't generally have a duty to retreat before using force in self-defense. And the statute provides that a person may use force against another person, when and to the degree a person reasonably believes force is immediately necessary to protect against another's use of attempted use of force or deadly force. And deadly force may be used when a person reasonably believes that there's an imminent danger of death or serious bodily injury. Shout out to Amanta, I can't say the name, but thank you so much. Danger, serious bodily injury, and that danger is real and honestly believes to be real, and the belief is founded upon reasonable ground. So the key language is reasonably believes. So again, we're going back to what that reasonable man standard is. First week in law school, you learn about the reasonable man standard. So you reasonably believe. In other words, you're allowed to be wrong. It just has to be reasonable. And to that degree, in Tennessee law doesn't give someone unlimited authority to use force. The force used must be proportionate to the threat perceived. In other words, you can't bring a gun to a fist fight. Okay? Now, if that fist fight causes for you to be on your back, getting your head bashed into the ground, you'll probably be justified in using that force because that fist fight has now become deadly to you. If you're a 70-year-old, 80-year-old person and somebody breaks in your house and they're trying to beat you up, you probably have a right to use deadly force because you're an old person, fragile, brittle bones. You see the difference? Okay? Again, the reasonable man standard. All right? Now, the force must be proportionate to the threat received. If a jury ultimately decides whether a reasonable person in the same situation would have believed deadly force was necessary. So Tennessee law also recognizes the defense of others. In other words, we talked about that. You have a right to defend other people, your children, your neighbors, your friends, people you love, even in some cases, strangers on the street. A person can use force to protect a third person if under the circumstances, as the person reasonably believes them to be, the third person would have been justified in using a force net. So if you see somebody getting beat to death with a baseball bat in the middle of the street, they don't have a gun, but you have one. Then you can use a pistol to stop the attacker from beating them to death. Because that would be the same, the third person that you saved would have had the same right to use deadly force. You see how that works? Think about that. That's the Tennessee, that's bystander. A bystander has the right to intervene. Okay? Now, the statute further limits self-defense claims when the person claiming self-defense was the initial aggressor. In other words, you the troublemaker. You can't come in and say, I'm using self-defense, but I was the troublemaker. Think about that. Somebody type troublemaker in the chat room. If a person provokes the confrontation, self-defense may be unavailable unless that person clearly withdraws. Somebody type clearly withdraws from the encounter and that other party continues to attack. Listen, think about it. If you picked a fight, you're a troublemaker, but you walked away and then they come after you, then you're no longer the aggressor anymore. You might have been the initial aggressor, but you clearly broke it off. You walked away and they chased you down. Now, for practical purposes, Tennessee law boils down to three questions. Was there imminent threat of unlawful force? Did the person reasonably believe force was immediately necessary? And was the level of force used proportional to the threat faced? If the answer to those questions is yes, then Tennessee law may justify the use of force, including deadly force, in an appropriate circumstance. Okay? If the force used exceeds what a reasonable person would consider necessary under those circumstances, then self-defense claim may fail. Some of y'all might not get this. That's okay. This is complicated stuff, man. I get it. This is criminal procedure. This is criminal law. I get it. They test lawyers for this on the bar. Thousands of lawyers every year fail this. It's complicated, but just keep listening. I'm going to try to break it down so you can understand. And that's why we're going to apply this. We're going to apply this Tennessee self-defense law to this Chud the Builder case. Let's apply it. Y'all ready? Somebody type, we ready in the chat room. According to the testimony presented during the preliminary proceedings, and we saw that when we put the little head down. We saw that, right? Surveillance video captured the confrontation outside the Montgomery courthouse. There was an investigator testified that Dalton Eatherly, known as Chud the Builder, he initially approached Joshua Fox. That's the brother. He was out there with his wife. Okay, they were sitting down under a tree. Okay, and here's the thing: Chud had his selfie stick, and so there was a verbal confrontation. Now, if we didn't know Chud the Builder's history, why was he walking up? Maybe he was just looking at the birds. But we know who Chud the Builder. We know he's probably over there harassing him, right? And this is the problem when you have a reputation in the community for being a jerk. Everybody knows you. So you over there with your little selfie stick, and you see a black couple, and you go over there and start messing with them. Got it, right? So they had a verbal altercation. Now the testimony, Eatherly said he walked away. Okay, he disengaged. That's what he said, right? He disengaged. What is the Tennessee law? Basically, you disengaged and you clearly walked away. Now, had Chud the Builder walked away and kept going, it'd have been fine. But that's not what happened. He walked away but then he re-engaged. This is according to what was said at the probable cause hearing. I want y'all to listen. And some of you all seen this video, which makes this very interesting. According to the testimony presented at the probable cause hearing, one of the courthouse employees, who apparently is a deputy or some sort of law enforcement, he reviewed the surveillance footage, and he testified that Dalton Eatherly, better known as Chud the Builder, pulled his firearm and began shooting at Joshua Fox before Joshua ever made physical contact with him. So what does that mean? That means Chud the Builder is walking up with his little selfie stick. They get in a verbal altercation. He then breaks off, but I guess Joshua is still talking to him. So he turns around and pulls his weapon and shoots Joshua Fox. That's what it seems like this is being said here. And so at that point, yeah, you might have tried to walk away, but then you re-engaged and you use deadly force against somebody, and there's no evidence that Joshua had a weapon on him. Think about that. So according to this testimony, it was only after Eatherly fired his weapon that Joshua Fox began to physically strike or fight him. Or what else are you supposed to do? Let him keep shooting you or go over there and hit him? A reasonable jury would say, yeah, that seems, I mean, other than falling down and dying, what are your other options? He's fighting for his life. But the most important point is that Chud the Builder escalated this confrontation to deadly force immediately against somebody who was unarmed. There's no evidence that he was armed. And so if that testimony is accurate, it creates a serious, major problem for Chud the Builder's self-defense claim. Why? Because self-defense is analyzed from the moment force is first used. If Eatherly introduced a gun, i.e. deadly force, into the encounter before Joshua Fox, the black dude who was sitting there with his wife under the tree, physically attacked him, then Eatherly becomes the initial aggressor for the purposes of self-defense analysis. And that initial walk away didn't matter because he came back. Does that make sense? Y'all understand that? Is that clear? Huh? Now, under Tennessee law, a person can't create a deadly force encounter and then claim self-defense. And based on the other person's reaction to being shot, you shoot somebody, and now you want to say he attacked me and you're trying to claim self-defense. That's not how that works. And so the timeline is very important in this situation. If this courthouse employee who saw this video, who testified as to what happened, and I believe the employee said, yeah, I saw the shells hit the ground before Joshua Fox even came over and swung on him. The guy was already firing at him. He didn't even have to shoot him. At the point where he pulled the pistol, Joshua could have took off on him. But the fact that the courthouse employee said, I saw the shells hit the ground, that means this man is actively shooting at this man before he even swings on him. You see? So now what? Now the defense has tried to argue that Eatherly initially disengaged from the confrontation. That don't matter. Okay? Okay, but the argument only works even if he did disengage from the confrontation. Let's change the scenario. Let's say he disengaged from the confrontation and old buddy came up in the back and socked him in the side of the head. Okay, that's ordinary force. That's a one-on-one match. Joshua came up and hit him on the side of the head, and then Eatherly pulls out a pistol and shoots him. You still can't escalate from ordinary force to deadly force. You see what happened? Does that make sense? See how self-defense works? So what I'm trying to explain to y'all is Dalton Eatherly has a problem. Okay? Again, the defense is going to argue that Eatherly initially disengaged from the confrontation, but that argument only works if he truly withdrew from the encounter. If the video footage shows that he re-engaged the confrontation, drew a firearm, and shot an unarmed man before any physical attack occurred, then the withdrawal argument just falls apart like wet tissue paper in a Chili's bathroom. You understand what I'm saying? You know how when you line in the toilet and then you try to sit down after you done line the toilet and the damn thing automatically flushes and now all the water been sprayed up and you sitting there and you got that water on that wet tissue and you got to hurry up and try to get in and out of that. Damn. I know we got some people that sit on the public toilet, but you know you got to line it. I know that's it, but the argument falls apart just like that. The argument falls apart just like that. You understand? This is the lady back here cleaning. Ma'am, I'm working. That's okay. Go ahead. Thank you so much. She had to get the trash. I'm about to go home. Can't be up here with y'all. But anyway, let me finish this up. Okay? All right? So where were we? Wet tissue paper. The argument falls apart like wet tissue paper. Okay? And there's another serious issue. So according to the facts, and I know somebody just gave me a super chat. The lady distracted me. You know what I'm saying? I'm here trying to focus and concentrate on this serious law. And she up here trying to clean up. I'm trying to do my job. She trying to do her job. Okay? But anyway, let's get back to this work. There's the other issue. Now, according to the facts that we have so far, there's no indication that Joshua Fox had a gun, okay? And Tennessee law permits the use of deadly force only when a person reasonably believes it is immediately necessary to prevent death or serious bodily injury. And while an unarmed person can, in some circumstances, present a deadly threat, like we saw in the Trayvon Martin case, where Trayvon was on top of the Zimmerman's head, bashing him into the ground, that's clearly a deadly threat. It's far more difficult to justify shooting someone who hasn't yet used deadly force against you. Do y'all understand the difference? You see, do you understand now? Are you beginning to understand? Huh? Does that make sense? In fact, if the testimony is correct from that courthouse employee, and Fox didn't even begin trying to fight Justin Eatherly until after he was shot, then the legal analysis, it flips entirely. At that point, Fox is no longer the aggressor. Fox is responding to deadly force that has already been used against him. And a reasonable argument can be made that Fox himself was acting in self-defense and after Eatherly introduced deadly force into the encounter. And based on the evidence we've seen so far, Chud the builder's self-defense argument faces some serious obstacles under Tennessee law. If the jury concludes that he approached the encounter, re-engaged after separating, drew his weapon, shot an unarmed man before any physical attack occurred, then it's going to be extremely difficult to convince the jury that he used it and it was reasonable. And the reasonableness is the heart of every self-defense case. The reasonable man standard. What would a reasonable man do? Now, of course, this is very early in this case. All right. I'm sure there's going to be additional evidence that's going to emerge and there's going to be more testimony and the picture may change. But based on the facts presently available right now, somebody type right now. Okay, based on the facts right now, the state of Tennessee has a very strong, straightforward argument to put Chud the builder in prison for a long time for the use of deadly force against Joshua Fox, who was unarmed. And Fox only began fighting after he'd already been shot or shot at. And if the jury believes a sequence of events, then Mr. Eatherly is going to go to prison for a long time. Somebody type booty bandit in the chat room. That's what's going to happen to him. You understand? You got a problem. They're going to be touching him. They're going to be chimping out on him all right. They're going to be bad situation. You understand? Now, what's the lesson? It's very simple. Don't mess with people. That's the lesson. All you white, again, earlier I said you have a right to say what you want to say in the United States of America. We have free speech. The government can't stop you from harassing people and saying mean things. The government can't do that. Okay? But what you're doing is picking a fight with people. And we are all Americans. And the most American thing that any American can do is fight back. Y'all understand what I'm saying? That's what we do here. We fight back. America, our national pastime is racism. And our favorite hobby is fighting back. That's how this country was born. Hell, we pick fights, we fight back, we fight. Every American. I don't care what any other country in this world, we outfight everybody. That is what we do. Okay? And you can't walk around the United States picking fights with people because it's somebody who got something for you. That's what we do, whatever color you are. Okay, so don't go around provoking people, because eventually eventually somebody is gonna test you. And when that day comes, it's gonna be very difficult to convince a jury that you were acting in self-defense if you're the person known all across the nation for harassing people, specifically targeting people with things like chimp out. You understand? You're known in the community for initiating conflicts and creating confrontations. One of the first things juries are going to look at is who started the problem in the first place. I know what the law says, but the jury is going to look at it and say, well, who's the troublemaker? Because that's what they're going to do. And one of the first things, look, were you minding your business? Or were you looking for trouble? Because on one hand, you got a man sitting under the tree with his wife on a hot, sunny day in spring, minding his business. On another hand, you got this other fella with a selfie stick over there calling them names, who has a reputation in the community for being a troublemaker. That's what the jury's gonna look at. And if your reputation is that you're always confronting people, always arguing with people, always provoking people, then you already put yourself at a disadvantage before the trial even starts. There's another lesson that every responsible gun owner understands. If you carry a firearm, don't get in fights. I shouldn't have to say that. Every concealed carry instructor in America teaches some version of that same rule. Avoid conflict. Walk away. De-escalate. Because once a weapon enters the equation, the stakes change dramatically. What might have been a simple argument or a fist fight can suddenly become a homicide case. That's why you never pull a weapon unless your life is genuinely in danger and you're legally justified in using it. A firearm is not a prop. It's not a fashion statement. So you see some people with these guns walking around like it's some kind of Birkin bag or something. They just, yeah, that's a 40-aught 50 I got strapped on my back, and I got the AR-15 with the extended clip in the back. These are not handbags. Who are you trying to impress? I get it. You have the right to do it. Fine. But it's not something it's not an intimidation tool. It's not something you display to win an argument. And the moment you introduce a deadly weapon into a confrontation, you transforming yourself from victim to aggressor. And that's the trap that Dalton Eatherly appears to have put himself in. Somebody typed trick bag in the chat room. See, if you become known in the community around the nation as a person who routinely carries a weapon and displays that weapon and then threatens people with that weapon or escalates confrontation while armed, you're creating a danger not only for others, but for yourself. And under the law, third parties, people looking at you, okay? People looking at you that you don't even know have a right in many circumstances to come to the defense of someone they reasonably believe is facing unlawful deadly force. In other words, if a bystander reasonably believes that you're about to shoot an innocent person, that bystander may decide to intervene. At that point, everyone involved is gambling with their life. Let me say what I'm saying. Had Chud the Builder pulled that pistol out on Joshua Fox and shot him, somebody walking by who himself or herself is a concealed carry could have shot Chud the Builder, and it would have been a justified self-defense of another person. You see how easy that goes, playing with guns? You see how that works? And so the ultimate lesson is this: carrying a firearm should make you less confrontational, not more confrontational. What do you need to fight for? What do you need to argue with people for? Go sit down somewhere. It should make you more patient, not less patient. It should make you more willing to walk away, not more willing to argue. Because once deadly force enters the picture, you're no longer playing the game. You're risking your freedom, your future, and potentially your life. And that's the bet. That's the bet no reasonable person should be willing to make. Now, I hope y'all learned something. I got to get on up out of here. I got a few more things to say, but I want to take the time to read these super chats. Did you all learn something? Did you pick up a few things? I want to give a big shout out to everybody who contributed to the super chat, the Cash App, and the PayPal. I appreciate you guys. I hope you all learned something. I understand you might be angry, but I don't care. Did you learn something? Mad or not, did you learn something about self-defense? The do's and the don'ts, as we call it, lessons of self-defense. What works and what will lead you to prison? Did you learn something? Shout out to my man Fuquan. Thank you so much. He says, well, he ain't say nothing, but he got a super chat. Another one for you. Thank you so much. And also we have, hi Dennis, how can you determine if Batson was violated in which it was race reason to remove black jurors purposely versus they all shared the same job? Okay, so here's the thing, and I talked about this recently. So what happens is you get these strike for cause, peremptory strikes, when you're trying to figure out which one of the jurors you want or which one of the juries you want to eliminate. You have to come up with a good reason for the call strikes. And I'm trying to speak in lay's terms because I know there's a lot of people who didn't go to law school. But the bottom line is you have reasons. This person can't do it because of handicap. This person is pregnant. Maybe strike for cause. Peremptory strikes, you don't have to explain yourself. So what jurors were doing is that they were using what prosecutors were using, they were using peremptory strikes to give it to black people, get them off the jury. There was a case, I think it was Batson versus Kentucky or Kentucky versus Batson. This guy was accused of burglary, armed robbery or something like that. Bottom line, or taking illegal goods or stolen goods. The prosecutor struck all the black jurors. And so they appealed that to the Supreme Court, said that's a violation of my equal protection rights under the Equal Protection Clause. And the jury and the Supreme Court said you don't have a right to your race, but they can't just strike people because they're black. And so the way in which you prove that these people were stricken because of their race is that you look at the voir dire transcript. Somebody type "speak the truth." Voir dire is a Latin word which means speak truth or speak honestly. And so that's recorded by the court reporter. So they're going to look at the jury printout. It tells you a little bit about the jury. So if the prosecution in the Carmelo Anthony case said, we struck these black women because they're educators of school-age children. They're educators and they're school-age children. Okay, were there any white women who were educators of school-age children? Did you treat them the same? Because if you didn't, then why not? If there were other school teachers with children of that age or children who were in school, then and you think that these black women cannot be impartial no matter what, well, what about these white women or these Asian women or these Latino women who are also school teachers? Why didn't you strike them? And so the court is going to look. So it's not just the fact that you had an all-white jury, or not even all-white, no blacks on the jury. You also have to show that these black people that you said you struck them because of, with your peremptory strikes, because of they were educators with school-age children, but you left these other people the same. You didn't do anything to them. So that appears to be bias. That's a pretext. In other words, it's a fake reason. Okay? And so this is going to be fact intensive. Now, if there's no other school teachers at all, it's going to be hard to prove it. If there's no other women school teacher, or there's no other women teachers with school-age children, it's going to be very hard to prove that. Just because you got no blacks on the jury, you're not entitled to a jury of your you're entitled to a jury of your peers, not a jury of your peeps. Okay, you're entitled to a jury of your peers, not a jury of people from your race. All right, so it's going to be fact intensive, and if the information is not there, it's not there. There's nothing anybody can do about it. I hope that answers your question. Very complicated question. Many lawyers don't understand that, but kudos to you for asking that tough question. That's a very, very tough question, and I try to lay it out so that lay people can understand that. Okay, I hope you all get that. That's for lay people. All you lawyers and quasi lawyers, we got the public is listening, and they don't understand those complicated words. Let's go back to who else we got here. Schooling T. Better. Is it true that Trayvon case, the prosecutor should have gone for manslaughter instead of murder? Yeah, if they could have included a lesser included of manslaughter and they didn't, yeah, that's pretty bad. But maybe they thought they had first degree murder. But I do remember something like that. They didn't have a lesser included charge of manslaughter. I do, in other words, killing somebody in the hot flash didn't mean to kill him. But you know, that's the prosecutor's purview. Okay. But anyway, thank you so much. Let's go to Denny. He says, follow up based on your legal opinion. What reason would the defense attorney not have Carmelo testify? Probably because if Carmelo testified, instead of getting 35 years, he might have got 95 years or 99 years. That could be possible. He just wasn't ready. I mean, you have all of you who have 19-year-old kids, 20-year-old kids, 17, some of these little mumble mouth boys, you don't want them saying anything. You want them to shut up and be quiet, don't you? Imagine putting him up on the stand and he break down crying, he up saying he's not guilty and he's crying, I didn't mean to do it, all that, and the jury hears that. And they like, yeah, he's guilty. He said he's guilty. You don't know what a young person is going to do. They might get broken down. Grown people get broke down on the stand. Expert witnesses, people who are trained to testify, highly educated people mess up on the stand and end up looking like idiots. Can you imagine what a 19-year-old boy under that type of pressure? You don't know what he's going to say. He might end up with 99 years. You see, the truth is 35 years, that ain't on the range of, you know, easy, you know, I can do that standing on my head to gruesome. That ain't really that bad. I know it sounds harsh to you all. He's eligible for parole after 17 years. The boy will still be in his 30s. He's still relatively young. Okay? Some of you all are second guessing the prosecutor. Maybe he knew something. Because see, once you put that defendant on the stand, everything is open. What if we learn that Carmelo Anthony had a prior incident with the same knife where he threatened somebody? What if we learn that? What if Carmelo now has to testify that, yeah, I'm not saying this, I'm not saying anything, but what if we learn that he had some issues with the knife before? Or he had a prior record somewhere, right? All of this could come up, you see? And maybe the defense attorney said, nah, we don't want to open that door for them to ask all these questions. So we'll just let him sit right here. Because again, he got 35 years. He might have ended up with 99 years. You understand what I'm saying, family? 35 years, he's eligible for parole after 17 and a half. That doesn't necessarily mean they'll give it to him. But at least he's eligible. At least he has a date. See, all my free world people who don't deal with convicts, there are people who will say, I got 250 years. I got 750 years. I got life, no possibility of parole. Carmelo Anthony at least has some hope. He can program. He can do the best he can. He can stay out of trouble. He has a date. You understand? Somebody type a date in the chat room. He has a date. And what I mean is, there's a date set where he can be eligible to leave prison. And at 35 years old, I know that's a long time. To go from 19 to 30, that's a long time. But the truth is, there's people who've been in there from 17 and they're 65 or 70. So more likely than not, he won't die in prison. And that's hard to look at, okay? But again, this is why I tell y'all it's better to walk away, because you all are going to forget about him by Christmas. And he's going to still be in prison. All of you all say he should have did this, he should have did that. Most of these people don't care anything about that boy. He's just another black boy in prison. You see? You see? That's it. But anyway, thank you so much. I appreciate that. Let's move on to the next one. And again, for you all who don't recognize the background, I'm in my office today. I had some work to do. This is kind of, look, that's me over there. Boom, bada, boom. Yeah. So, yeah. I had to come in here and have some meetings with some clients and whatnot. As you all know, I'm a personal injury lawyer. That's the area of law I practice. But anyway, let me get back to this work. Somebody type that work in the chat room. Enough about me. Let's go on to Fuquan. Thank you so much for the $5 super sticker. Thank you again, Fake Quan, for the $5 super sticker. And Greg, let's read this name. Lesmond Jr., thank you so much. I appreciate you. We got another $2. Tadisha Brown, thank you, Uncle D. Look, I know it's people who don't like me telling you this stuff, but it's the truth. This is just what the law, I'm just explaining to you all how those verdicts happen. I get it. Racism exists. I talk about it all the time on my page. But for some of these cases, you don't even need racism. You don't need they didn't need white supremacy to convict Carmelo Anthony. They had a dead body, a murder weapon, 20 witnesses, a confession, and videotape. They didn't need to bring out the ace of spades for that. Why do you need white supremacy on that? In what state in America does a person not go to prison or get the death penalty when they got the murder weapon, a dead body, broad daylight, dozens of witnesses, video footage? Where did you not go to prison? In what state did you not go to prison with all that evidence? You understand what I'm saying? So I get it. Racism exists. As I tell y'all from the beginning, it's not going anywhere. Racism is as germane to the United States as the weather. It's not going anywhere. It's something you're going to have to deal with. We are just going to have to try to figure out how to get along. Racism or not. Or we just going to tear our country up. Every time we get a case like this, we just going to blow up and riot and threaten civil war and race war. How are we going to live like that? I'm just asking. How are we going to live like that? So at some point, cooler heads have to prevail. Again, there's always going to be people who don't like you because of your religion. There's always going to be people who don't like you because of your race. There's always going to be people who don't like you because of where you live or how you sound. It's going to be people who they just don't like you because they don't like you. I don't care if you don't like me. That's why our ancestors built institutions. That's why we have HBCUs. So we don't have to deal with it directly. That's why we have our own banks. That's why we have our own neighborhoods. That's why we have our own churches and ceremonies and holidays. That's how you insulate yourself from racism. You create your own institutions and you protect them. Have y'all not figured that out? You've been listening to me for years. Because racism ain't going nowhere. So you build a bivouac to protect yourself. It's what any intelligent group of people doing in a social climate. But anyway, that's another subject. Let's get on back to this self-defense. Somebody type self-defense in the chat room. Shout out to Curtis Smith 2020. Appreciate your perspective. Keep saving lives. Yeah, I hope I am. You got people out there thinking they can do anything. You better calm down. Somebody said, take these funky dollars, D. In the long run, the most unpleasant truth is a safer companion than a pleasant falsehood. Yeah, I'm not going to lie to you. I am not going to lie to you. I'm probably one of the only lawyers in America that's going to give it to you straight because I don't even want your money. Sometimes I will tell people how bad their case is just because I don't want it. I've done that to people. And the crazy thing is I had a case, I don't want to talk about it too much. I told this guy, look, man, you got a horrible case. This is the most I can do for you. And just because I really didn't want the case, I said, it's going to be six figures. You're going to have to pay me 6 figures. You understand that? And the dude still paid me. And he was successful in the goal and trying to, but I didn't want the case. And sometimes I've learned that telling people the truth, they may not like it, but they actually appreciate it and they respect the fact your integrity. Tell people the truth. That's what I do. I'm going to tell you the truth. I'm going to tell you this bold, cold, hard truth. I'm not going to hold back. And people who genuinely appreciate that, they'll come to you. I've got so many people call me. So many people have called me just this week. I got an environmental case that was referred to me out of Colorado. I got a car accident that was sent to me from Florida and California. Like, man, you get rewarded for speaking the truth, not for catering to people's feelings. Now, again, I'm not right wing. I'm not left wing. Some of you all know I've been a Democrat my whole life. I voted for Trump the past 2 times because that was in my interest to do that. That doesn't mean I'm a dedicated Republican. It just means, hey, I like what this man's platform is. Vote your interest. I don't even tell y'all what to do. Do what is best for you. You understand what I'm saying? Vote your interest. You understand? But again, I'm going to keep telling y'all the truth. That's what I've been doing. That's why I don't have any viral videos. I got 100,000 followers with no subscribers with no viral videos. What does that tell you? That tells you the people, this channel is personality driven, and people like what I'm saying. They like the information. It's not about the glam and the optics. It's just me talking to you all, trying to help you understand, trying to help you get there. And to me, that's a blessing in itself. But anyway, let's move on. Shout out to Cesar. You talked about it before, and I'm 100% agree. The problem isn't the outcome of the verdict. The problem started with the decision to use deadly force. Yeah, once you use deadly force, you start creating problems for yourself. Just showing appreciation. Thank you. T-Love. Let's see here. People don't even respond in violence when being called the N-word with the hard R. We're debating conflict resolution involving children. Be blessed. Yeah, man. Thank you so much. I appreciate that. But anyway, I got a couple more things to say. Shout out to everybody who contributed to the Super Chat, the Cash App, and the PayPal. You all are the real MVPs. I appreciate all the new people. Make sure you subscribe to the channel. I got a couple more things to say before I ease on out of here. And I want to do that. Okay. And well, I didn't put the Cash App. That's actually my cell phone. I messed up, man. I should have put the Cash App down there in case you all don't want to fool with YouTube. But anyway, I'll put the Cash App down there. But again, you don't owe me anything. I appreciate being here. It's an honor to be able to talk to you all. It's an honor to be able to speak these things out there and you all debate them. And I do look at the comment section. If you say something crazy, I'm going to ask you to explain yourself. But, you know, regarding self-defense and what it means, as we bring this discussion to a close, I want to leave you with the single most important lesson from everything that we talked about today and all that we have been experiencing as Americans over the past several weeks. Okay, self-defense is not about who you like. Okay, it's not a racial sport. It's not a team sport. Self-defense is not about who you dislike. It's not about who. Self-defense is not about race. It's not about politics. It's not about what happened 5 minutes before the confrontation. Self-defense is about one question. What would a reasonable person have believed at the very moment force was used? That's it. And when we looked at George Zimmerman, the lesson was, and you don't have to like George Zimmerman. I don't think most people don't like him. Okay? The lesson was, in that case, was that an unarmed person can still present a deadly threat under certain circumstances. When Trayvon Martin was on top of him, punching him, and this is the evidence. Maybe it's true, maybe it's not, but this is what the jury heard. And see, that's another thing. It's not what actually happened, it's the evidence that the jury heard. That's hard for people to swallow, but that's it. That's that cold, hard truth that you don't like me for. Because I'm going to say, I don't care what happened out there. I care what the jury heard. I'm sticking to the law and the lawyering, and I'm saying whatever was presented to the jury. The jury heard that Trayvon Martin was on top of George Zimmerman, bashing his head into the pavement. And they said deadly force was justified. Same thing when we looked at Rick Chow. The lesson was that you don't have to wait until a weapon is fired before defending yourself or someone else. So when Rick Chow perceived that Cyrus Belton was aiming a pistol at his son, Andy Chow, that was the testimony. That's what Andy said. Yeah, it may be biased. Hell, he might be lying. But that's why he was subjected to cross-examination and the jury heard what he had to say. He might have been lying through his teeth. But that's what he testified to. That was the evidence. It was subject to cross-examination. We'll never know. But he did testify that Cyrus Belton pulled a pistol on him and his daddy shot him. His daddy shot him. And he didn't have to wait till Cyrus Belton shot at Andy Chow first. The law allows reasonable people to act on reasonable perceptions of danger, even if they were mistaken. That's the reasonable man standard. And now when we looked at Carmelo Anthony, the lesson was you can't respond to ordinary force with unreasonable deadly force. And self-defense requires proportionality. Again, I changed the scenario. if Carmelo Anthony was on the ground getting beat up by a bunch of people, he had a right to use deadly force because at that point, it is perceived, a reasonable person would interpret a bunch of people beating you up as about to cause serious bodily harm. If they had started pushing him, even while he was standing up, punching him, even while he was standing up, he didn't have to fall down on the ground. He could have used deadly force. A reasonable person would assume that all these people around me attacking me, my life is in danger. They're going to cause serious bodily harm. That wasn't the testimony that came in. That was not the testimony that came in. None of those twitting witnesses said that this young boy's life was in danger. So that's not the evidence that the jury heard. And so all they heard was that one boy pushed another boy. He was unarmed at the time he pushed him, and the other boy stabbed him in the chest. And they said, that's self-defense. You had a right to self-defense, but you overdid it. That's the law. That was the evidence. The jury was charged with applying the evidence to the law, and that's what they did. Now, when we look at Chud the Builder, the lesson was if you spend your life provoking people and escalating conflicts and creating confrontations, eventually you're going to run across, you're going to find yourself in a situation where self-defense is not going to save you because you are the one that created the danger yourself. And the common thread running through every one of these cases is reasonableness. Not emotion, not outrage, not social media, reasonableness. The law rewards people who avoid conflict. The law rewards people who de-escalate conflict. The law rewards people who walk away when they can. And not just walk away and stay away. The law doesn't reward people who go looking for trouble. And if you carry a firearm, you need to be the calmest person in the room all the time. If you carry a firearm, you should be the person most willing to walk away from any argument, no matter what they say to you. You ugly. Your mama fat. You built like a Mack truck. You got a bald head granny with a kickstand and a wooden leg. Walk away. If you carry a firearms, you should be the person least interested in proving that you tough. Okay? Because the moment you introduce that gun or that knife or that deadly weapon into a situation, you're no longer arguing over pride and ego or respect. You're gambling with your freedom, your future, and your life. And the biggest misconception people have about self-defense is believing that it gives them permission to win a fight. It doesn't. Self-defense is a legal justification for using force where there's no reasonable alternative. It is a shield, not a sword. The best self-defense case is one you never have to make. The best gunfight is one that never happens. The best criminal defense is avoiding the conduct that puts you in front of a jury in the first place. You do not want to be judged by a jury. So if you take one thing from this broadcast, let it be this: control your emotions. Control your temper. Control your ego. Don't threaten people. Don't provoke people. Don't jump people. Don't pretend you have a weapon. Don't pull a weapon if you have one unless your life truly depends on it. See, every self-defense case is going to be judged by 12 ordinary people who are going to ask one simple question: was what you did reasonable? If the answer is yes, the law may protect you. If the answer is no, you may spend the rest of your life wishing you had walked away. And I hate for you to be in that situation. I want to thank you all for watching this broadcast. I want to thank everybody who patiently sat through. I hope you appreciate what I did. I hope you learned something. And whether you like it or not, somebody type boule sold out. I want all those words. Help me get all of them. What? Bootleg, raccoon. Get all that in there. If the truth makes you respond like that, then it's working. Because it means it hurts you. The truth hurts. Lies make you feel good. If you hurting, if your feelings are hurt after I said all this, then I'm doing what I'm supposed to do. Nevertheless, this is Uncle D. And as always said this time, I am out.
In the Spurling podcast, hit the like button, subscribe.